admit that he is a kick-ass trial lawyer. And when Hunter S. Thompson was arrested for DUI in Colorado, and some of the most famous lawyers in the country came to represent him for free, and they suddenly realized at a certain point that they might actually have to try the case, they called Exam-Hutt and deal with it. And Abe will tell you in the cave about how he ultimately resolved the case, which is a brilliant story in and of itself. But after the case was resolved, and for years afterwards, if you were to go into Hunter S. Thompson's home, you would see on his, maybe his refrigerator or his wall, photographs of him with Bob Dylan and with, I don't know, all kinds of famous actors, and you would see a photograph of him with Abe Hutt, because that's the kind of lawyer he is.
In my experience, there are all criminal defense lawyers fall into three groups when it comes to cross-examination. The first are people who are naturally good cross-examiners, and I have no doubt that there are some of you in this room. The second people are everybody gets I'm supposed to have a microphone. The second group are
Hello. Hello. Testing. 1, 2, 3. Testing. I am your father.
The second group are people like me who are not naturally good cross-examiners and who struggle with this and have a hard time with it and find it to be, if not the hardest part of trial, I now believe to be the second hardest part of trial behind voir dire. The third group, and largest group, are people who think they're in group 1. And are in fact in group 2. Now, what I can tell you is I was not any good at this when I started. I know I was not any good at this when I started, and I can tell you stories till the cows come home about how balled up I got in the cross-examinations that I began to do. What I also can tell you is that what Paul told you is true. I studied at the feet of the master. Larry Posner is a naturally good cross-examiner. More importantly, the things that I'm going to tell you and try and teach you today, virtually all of which are stolen from him, made him a much better cross-examiner. So I watched somebody go from being naturally good at this to being phenomenal at it, to being on another planet, by the application and development and the teaching of these techniques that we're going to talk about and that the rest of these extraordinary people are going to talk to you about from tomorrow on through to next week. So even those of you who happen to be right, that tiny minority of you who happen to be right about your thought that you're in group 1 and are naturally good cross-examiners, pay attention. It will make you even better, okay? I promise. Oh, it is a pointer. Okay. Now, here's the thing. You have heard lots and lots of language here in the course of the last few days, and will hear more as the time goes on, talking about how we are warriors, right? We felt warrior in our hearts and guts yesterday at the end of Paul's lecture. That's Paul right there. I felt it too. The problem is, when we think of ourselves primarily as warriors and fighters, it does us a disservice. And here's the thing. I used to title this slide, "What Really Good Cross-Examination Looks Like," because it's what really good cross-examination feels like to most of us, okay? And the fact is that, you know, sometimes it happens this way. It works out this way. This is the bad guy. That's the snitch, okay? This is me. I want this is me doing good crimes, okay? No, this is me doing really good crimes. That guy, I am going to throw him off the bridge, right? Isn't that what it feels like when we really... Yeah, okay, so it happens that way, and it happens sometimes that way. But the problem is that if that's the only way that we really think about ourselves, we're missing out on all sorts of really important stuff that we need to accomplish for our clients. And so I say to you that that's not really the image that you should have in your head, right? We like it, we love it, it makes us feel good, and it is important. Make no mistake. But we cannot feel that way at the expense of having this picture in our minds of who we have to be. This picture and this one, okay? Because that's who we really need to think of ourselves as being in cross-examination. We need to be teachers to the jury, teachers of the jury, students with the jury of these very important subjects that we're going to present, and we need to be storytellers. We need to be taking what we have from the government's witnesses, from the state's witnesses, and taking those pieces and taking those gems and building the kind of story in exactly the kind of way that Paul was telling us to yesterday. And we can do that in cross-examination. And if we are only thinking about how I'm going to kill this witness, how I'm going to rip his guts out, we won't get there. We'll abandon many opportunities that we have to advance our theory of being the case. So, like I told you, good lawyering is all about theft. And this is the book that a lot of this stuff got put into, all right? Larry Posner and Roger Dodd's book on cross-examination. It is a phenomenally good book. It is a phenomenally expensive book. So what you want to do is like form little cartels so that you can buy one of these books, okay? Now, I'm actually now told that there's a student version of it that is less than the $400-something that they want for this book. 125 for the student version. And who you have to be, Lori Shanks, to be a student? If you send Lori Shanks, wait, is this being recorded? Lori Shanks says if you send her an email, she will assist you. There might be an agreement formed. There might be an overt act that takes place. This results in you receiving an underpriced copy of this book. It is a phenomenally useful tool. It is full of so much good practical stuff, so much more good practical stuff than are in the vast majority of books that you see, that you want to get yourselves a hold of it. Okay, enough with that, and understand that good cross-examination is all about preparation and control, all right? I want you to become the Martha Stewarts of cross-examination. I want you to spend it, for any 15 minutes that we spend cross-examining in a courtroom, we need to spend at least 4 times that amount preparing it. It's simply that hard a thing to do. And it's that important a thing to do, and it's what accomplishes what we're going to tell you you're going to accomplish in the courtroom, right? Why? Because I tell you, I have, I want you to have pictures to go with, these concepts. Preparation and control is Martha Stewart, and I am the poster boy for anxiety. And I have the prescription for Ativan to prove it, if none of you. Look. This is a difficult task in which you've got all sorts of things going on at the same time. You need to pay attention to the witness. You need to listen. You need to figure out what objections are coming from the prosecutor's desk. You need to figure out what it is that the judge is going to be doing. You need to pay attention to what it is that your client's doing at your table, right? And you've got hundreds of pages. Maybe you only have 10 pages. But they're all handwritten, right, of discovery that you've got to try and keep straight as you're doing your cross-examination. All of that makes me incredibly anxious. And so all of these techniques are designed to decrease that anxiety and place it instead on the witness. The more confident you are, the better you're going to be able to tell your story. The less confident the witness is when it comes to doing destructive cross-examination, the less confident the witness is going to be. What do I mean? Destructive versus constructive, right? Do you say to yourself, this witness has told a story that I need the jury to disbelieve in order to advance my theory of the case? In which case, I need to destroy that story or do some damage, some major damage to it. Or am I saying this is a witness who I may like or dislike, but regardless has some good facts that advance my theory of the case? If this witness has a good fact that advances my theory of the case, I need that fact out. I need to make that a big deal in my cross-examination of that witness, right? I don't know about you all, but the cases I get to try are generally not top-heavy with wonderful defense facts, right? They tend to be top-heavy with wonderful prosecution facts. And I am looking for the little things that I can make a big deal out of. Or as the extraordinary Tony Serra says, you find those things in your case that you can feel self-righteous about, and you build a cathedral around it. You ever felt like that? That you've got like a couple of little things, but by God, you are going to build a cathedral around it? That's what we do most of the time. And we cannot pass up the opportunity. And if all we're doing is looking to fight with the cops because they're cops, we'll pass up the opportunity to build our story with those few good facts that those cops can give us. Oops. Oh, I have pictures. Now, the fact is that sometimes we do have to do destructive cross, right? The fact is that plenty of times the reason that they called the witness was that they were going to say some stuff that we don't like, and that we don't want the jury to like, and that we don't want the jury to believe. And we're going to have to do something about destroying. But what again I want to go back to is choose your weapon carefully and choose it wisely when you're going to be a warrior. And I will tell you that the vast majority of time, maybe all of the time, I think I'll go so far as to say all of the time, that is not the right weapon, okay? That's the right weapon. A good cross is done with a scalpel. It's not that we're coming in with these huge hammer blows and destroying the witness. What we are doing is we are making very precise and very tiny cuts from which the prosecution's case will lead to death, without them even knowing it. Ever cut yourself with a razor blade and not realize it until all of a sudden there's blood? That's what we are about in cross-examination. We are very precisely making surgical cuts to point out what's wrong and to remove what's cancerous from the courtroom. Okay, here we go. Terry, who's sitting over here, told us at the faculty meeting that he is just old enough to have seen an extraordinary lawyer and teacher named Irving Younger, who for many decades was the king of cross. Talk about his 10 rules of cross-examination, some of which are included and synthesized in here, but it really can be made very, very simple. So we're going to go through them. First, only leading questions. We'll come back and we'll talk about these in more detail. I'll give you some time to see the 4, but trust me, not only are you going to see them again in this PowerPoint, you are going to hear about them tomorrow from this band of brigands, to the point that you will want to pull your hair out, okay? That's how I got this way. Seriously? Jeff, will you please explain to him? This whole new thing about having the faculty over here, it's a problem. It's a serious problem. We're only going to ask leading questions, and they are going to beat on you until you are bloody tomorrow if you don't ask leading questions. And we'll come back for the reason to that, and we'll come back and we'll have debates, but the bottom line is we're only going to ask leading questions, period, end of story. We'll come back to it, I promise. 2, you're only going to ask one new fact per question. Only one new fact per question. 3, you are only going to ask short questions. And what you and I as lawyers think is short is not the definition, okay? Only short questions. And 4, we are only going to ask questions that lead to a specific conclusion. And not just any specific conclusion, but to a set of specific conclusions that you craft at the beginning of your case and as you're preparing this. And we'll come back through that. By far, I think that 4th is the most important. All right, so only leading questions. Why only leading questions? And it's for a whole variety of reasons, okay? First, that's not one. So we're going to go back. And I'm going to say that the reason that we do only leading questions is that good cross-examination is about you testifying. Okay? The witness becomes a prop. The witness's only job in life is to say yes to the story that you are telling, to the facts that you are putting before them, to your own credibility that you are placing in front of the jury. Which, make no mistake, although it is the one thing that we are absolutely never allowed to do in a courtroom, right? We are never allowed to say, I believe that Don McCarthy is innocent. It's what we do with every fiber of our being every time we stand up to talk in the court. And we have to know that, and we have to communicate that. We can't ever say it, but that's what we're doing. Our own personal credibility is on the line here. And what we're doing when we testify, just as surely as any witness takes the witness stand, is we are testifying. Right? So we are making statements of fact that the witness is agreeing to and that the jury is hearing as evidence. That's the idea. That's why only leading questions, because we're making statements of fact. Okay? The other reason that we're doing it is that it creates a rhythm. It creates a rhythm that makes it much easier for the witness to just say yes, and for us to get our story out. It makes it much, much easier for you to control the witness. Remember Martha Stewart? It's all about preparation and control. You want to be in control of this story. You can tell it better than anybody in the courtroom. Right? That's why we do this work. We're good storytellers. You wrote the story. It's the client's story. And it's the client's truth, but you wrote it. You wrote this version. Just as Quentin Tarantino, who I hope wrote that movie and didn't just direct it, wrote that movie. Right? You're writing this movie. You need to be in control. What do I mean by leading questions, right? The law says it's a question that suggests the answer. All right, so how do you feel about drinking? It's clearly open-ended, right? Do you like to drink? There are lots of judges that believe that asking a question that begins with do you, and then something at the end is a leading question. And I say horse hockey, okay? That ain't a leading question. You like to drink is a leading question. Even better, you drink, you like it, are two really great leading questions, okay? And notice that they don't have question marks at the end of them. The nicest thing that any court reporter has ever said to me is calling me up on the phone to say, Mr. Hutt, I'm doing this transcript of your hearing. Do you want question marks at the end of what you said because they don't sound like questions? Hooah! I know when I'm crossing what I want that transcript to look like, right? I want lots of white and very little black. Not racist. Lots of white and very little black. Okay? Why? One line, one word. One line, one word. One line, one word. Because that's also the rhythm that I want. Because I want this witness saying yes. I want me to be telling my story to the jury, my client's story to the jury, to the judge in motions hearing, and for the witness to be affirming it and saying yes. Okay? We're only doing one new fact per question. Why? It solves problems for us. And again, remember, this is all about being in control and turning down anxiety. How do we make sure that we get the witness to this conclusion that we want? How do we make sure that the witness doesn't run away from us? How do we make sure that the witness doesn't give us some answer that goes off and takes the story in a direction that we don't want it to go? One new fact question gives you better witness control. It makes it much clearer what the answer is. And I probably should be giving you examples of this. So, what's a good example of what not having one new fact per question? It's something like, I asked the leading question, you saw the red car speeding down the road and swerving out of its lane. No. What do we know? That the car wasn't red, that the car wasn't swerving, that the car wasn't speeding. Which one of it is, right? So we want to be very clear for the jury. The other thing so we're clarifying. One new fact per question doesn't give the witness the ability to mess with us, right? And there are some witnesses whose job it is to mess with us. The problem is that we presume that every police officer sees his or her job as messing with us. And they don't. And if we treat all of them like that, it is a disservice to our clients. Not every snitch sees it as his or her job to screw with us. A lot of them do. You gotta figure out who it is that you're dealing with, and we'll talk about that. Much easier impeachment, okay? If I say the whole red car speeding, swerving out of its lane, and the witness says no, and I know that the witness previously has said yes, it is a whole lot easier for me to do that impeachment, which you will have a whole nother lecture on next week, and which you'll have lots of time to work on by itself because it is so incredibly important to what we do. But it's much easier if we have been short and we have been clear, and it's very clear to the jury the picture that we are painting. You know, 2 weeks ago he said this, today he said this one is a lie, and the previous one is the truth. And we can paint that much more clearly if we've asked one new fact per question, and when we go to impeach, we're impeaching on a small, discrete thing rather than a big, messy thing. It also gives us, this one new fact per question, gives us more detail, more opportunity to paint the kinds of word pictures that, my God, you heard such extraordinary examples of in these openings, right? In which I know everyone was talking to you today about painting word pictures. Well, why the hell can't we do that in cross? We can't. And if we're adding one new fact per question, by God, it encourages us to do that. It encourages us to add the detail and to paint the picture. It allows you the opportunity to do repetition without being repetitive. Okay? Rhyme, rhythm, and repetition. We're only going to do short questions. This is a wonderful quote by Faulkner about Hemingway, right? He has never been known to use a word that might send a reader to the dictionary. Take that advice. Be Hemingway and not Faulkner when you're crossing. Remember who your audience is. Remember that you are teaching them about stuff that they probably had absolutely no idea about before they ever walked into the court. Teach kindly, teach simply. Why only short questions? We've talked about rhythm, this does the same thing, right? It's obvious that the only proper answer is yes. This is critical for the witness who is messing with you. You ask a long question, it's not obvious to the jury that the only appropriate answer is yes. You ask a very short question, it is. And when they do, the kind of thing that my mother, may she rest in peace, would say, you know, he's the kind of person that if you ask him what time it is, he'll tell you how to make a watch. We get those kinds of witnesses. FBI agents are trained to be that kind of witness. The car was red, wasn't it? Well, counselor, I'll tell you, I was seated in a position of reconnaissance, which I had been trained upon for the preceding 11 years to be a very special agent. Right? And 10 minutes later, he's still talking. And you still don't know whether or not it's a red car. We're being clear for the jury with very short questions. They cannot follow when you do your normal lawyer thing and talk in long sentences. The short questions decrease your anxiety. They are easier to write, they are easier to get on the page, they are easy, the rhythm is good for you as well. And they are critical when you need to regain control. When you have lost control of the witness, and you need to do something to regain that control, those short questions are absolutely critical. And we'll talk about that, I hope, somewhere in here. Yeah, we'll get to it. All right. Only questions that lead to a specific conclusion or goal. You're going to hear lots and lots tomorrow about chapters of cross-examination, and this is really the heart and soul of this method of cross-examination, is writing cross in chapters, doing cross in chapters. And chapters simply mean that we are designing a set of very specific goals that we want to achieve in cross-examination, right? So, this is a diagram of a chapter of cross. And I will tell you that a chapter of cross is only one page. Period, end of story. Bright line rule. It's only one page. The reason for that is that it makes your life easier. It keeps you better organized. It gives you more flexibility. It puts you more in control and therefore makes your cross-examination better because it means that you are doing what? Advancing your theory of the case, which is the one and only reason to do anything in a courtroom ever. That's one chapter of cross. Let's break it down even further. I like this thing, it's kind of fun. First of all, the chapter has a title, right? Whatever the subject is, it has a title in big bold letters, even when you are young, so that you can see them, that tells you what that subject is. Why? Because that allows you to be more flexible, right? It allows you to take that piece of paper and say, I don't want to do that 1/3 in order the way I thought I did when I was preparing this at midnight last night. I want to do it first. I want to do it last. I now need to bury it someplace in the middle, right? Like the Tennessee Tenderloin, thank you. It's some topic that's important to your theory, and then it leads to a conclusion that you want the jury to make about that topic, okay? It's simply a topic important to your theory of the case, and it's a conclusion you want the jury to make about that topic. All of this makes a whole lot more sense. And what's in the middle are the facts that support that goal, that lead the jury to that conclusion, okay? What goes in the chapter? everything that the witness must say. Every fact that you know the witness must conclude, must agree with about that subject. Has to be sourced. How do you know that the witness must say that? Because you have some source, some document, some recording, something that tells you absolutely for certain, rule number 1 from Irving Younger's 10 Rules of Cross-Examination, never ask a question that you don't know the answer to. Well, the reason that you know the answer, the reason that you can make this statement and the juror the witness is going to agree with it, is that you not only have a source for it, but you have put onto the page what the source is. I know, this is really anal, okay? That is in fact not my diagnosis. My diagnosis is not OCD. My diagnosis is anxiety disorder, okay? It's not OCD. I'm not telling you this stuff simply because I'm anal. I'm telling it to you because it works. Because what happens if you don't have it sourced is when the witness doesn't give it to you, you don't have the ability to impeach. And when you do have it sourced, you have the ability to impeach immediately and effectively. And you'll get plenty of chance to practice. What goes in the chapter is those things that the witness will give you, right? Maybe not must, but will. How do you know what things the witness will give you? The same kind of way. Your investigator's done an interview. You've done a motions hearing. You have a transcript. You have discovery. You have some piece of something that tells you this witness is in fact going to concede the point that you're making. Maybe it's logic. Maybe the point that you're making a witness hasn't specifically said before, but it is the only logical thing to conclude from every other thing that that witness has said, right? Maybe it's the witness's personality that tells you that that witness will give you that answer. How do you know the personality? You have to have had some contact. If it was not for investigators, we could not do this work, period. And if you don't learn how to use them well and make friends of them and make partners and allies of them and understand that you cannot win a case without them, you'll never get anywhere in this business. And if you've done that kind of work before, any investigators or former investigators, these people are gold, okay? They are gold. Their personality, their character, your experience in life may tell you something about this witness is going to have to give me this. What stays out of the chapter, okay? Anything that doesn't lead to your conclusion in that chapter, the point that you were trying to make, and I will get to some good examples of this for you, I promise, so that we try and get out of the abstract and into the very practical. Anything that does not lead to your conclusion. You may be able to make a great point. You may be able to land a blow. You may be able to make a cut. If it doesn't advance your theory of the case, don't do it. Period. End of story, don't do it. What the witness can never say, right? We often refer to this as one question too many. When we lead witnesses, we are leading them to a conclusion, right? We are leading them. I've said to you, the whole point of a leading question, of a set of leading questions, is that we are leading to a conclusion. It's not a conclusion for the witness to make. It's a conclusion for the jury to make, or for the judge to make. And there are certain things that the witness, no matter how good you are at this, no matter how much you follow these rules and how much investigation you've done, there are certain things that are true, that you know to be true, that you know the answer is yes, that the witness must always say no. We'll talk about those. All right, so here's my big example. How many of you tried DUI cases or seen a DUI case? Good, excellent, perfect. How many of you know what horizontal gaze and nystagmus is? Right. Can't have being in group 1 and not be in group 2. You got to know what horizontal gaze and nystagmus is. For those few of you that have not, it's an eye test that the cops do to figure out whether or not you have alcohol in your system because your eyes do a funny jerking motion. Okay? That jerking motion can be caused by strobe lights as well as by alcohol. Okay? Now, What do we want to, one of the conclusions that I want a jury to make in a DUI case where I'm attacking this is that strobe lights caused this client's, his, horizontal gaze nystagmus. So the title of my chapter is Horizontal Gaze Nystagmus Lights, okay? The reason for that is that when I started trying DUI cases 30 years ago, I thought, okay, Posner told me I gotta have chapters, I need a topic that's important to my case. Well, I know that a topic that's important to my case is roadside sobriety tests. So I started to write a chapter, longhand, before computers. Started to write a chapter on what did I say? Roadside sobriety tests, right? Got to the end of the first page, hadn't gotten very far into that topic, right? It's gotta be one page. So I said, okay, fine, we'll make every test its own page, right? That'll work. Started a chapter on horizontal gaze nystagmus, way more than one page. And it evolved down into what I now do, which is probably 6 or 7 chapters on horizontal gaze nystagmus, simply so that I am keeping myself organized and say to myself, I have 6 points that I need to make to the jury about horizontal gaze nystagmus. There are 6 conclusions that I want the jury to reach about that in order to advance my theory that this client was not drunk and that the roadside tests prove that he's not drunk. That's my theory of the case, right? Here. All right, so we've got the topic, we've got the conclusion. How do we get there? 1, strobe lights can cause horizontal gaze nystagmus. Now that's a nice place to be able to start. Why can I start there? Because at page 28, line 23 of the motions hearing in this case, when I asked this question of the cop, he gave it to me. Woohoo! This is a good day. Actually, it was a total nothing day at the motions hearing, right? Because I could give a rat's ass at the motions hearing about whether or not strobe lights cause horizontal gaze nystagmus, because it ain't going to win that hearing for me. It ain't going to do anything for me at that hearing, right? But I know that it could do a wonderful thing for me at trial. All right, so strobe lights can cause horizontal gaze nystagmus. You had strobe lights on your car. We're adding one new fact per question, right? The lights are red and blue. Violated my own rule. What should I have done? Right? Because it makes the rhythm better, right? And when I wrote this, I should have done it that way. They're bright. Let me go back for a second. What do you notice about the lights of red and blue when they're bright? No question marks. What else? From out here, please, I'm sorry. No source. Right. Now, so what does that mean? It means I can't impeach, right? Does it mean that the witness won't say it? No. Because what the hell's he going to say? Right? Logical, common knowledge, whatever. I can ask questions that he hasn't specifically answered. Now, what the hell I was thinking at the motions hearing when I didn't say they're red and blue and bright, I don't know. But I wasn't. They're designed to be seen from a long way off. I got that one in at the motions hearing. I got in there very effective. I got that they reflect off of everything. No source, but it's logical. I get your car is parked behind Mr. W, that's the client. Your car is parked behind his car. The strobe lights are pointed at the rear of his car. You had him facing the rear of his car. Your flashing lights were reflecting off of his car. So, your lights caused his HGN. Why are you shaking your heads?
That's one question, more question.
Sorry?
One question too many.
One question too many. Will he say yes when I say so your lights caused horizontal gaze nystagmus? Can he ever say, right? Does it stop most of us from asking that question? No, because the rest of this stuff felt so good that we know this is right, this is absolutely right, we just proved it. And we say so, and he says no, and now what do? You got to go back and do the whole thing again, right? Trust me, it is never as easy the second time around. He ain't going with you quite so easily the second time around. Now you're going to have to impeach on every single one of these and deal with his argument to you about, well, I know that they reflect off, but even so, right? Quick rule. If you find yourself in a courtroom, at a podium, with a witness on the stand, and you hear yourself say the word so, stop, think, don't finish the sentence. Right? 9 times out of 10, what you are about to do, it may be that 10 times out of 10, in that circumstance, what you're about to do is ask one question too many and make your life much more difficult and undo what you have just spent some time, a lot of hours of preparation accomplishing. Okay? Don't do it. So, we're not going to say that, and we're not going to say this one either. Your lights cause today's chant, right? We're not going to say the conclusion. We don't need him to have reached the conclusion because of what we did. The jury reached the conclusion. Okay? This is the same kind of thing. I just want to give you another example from a murder case with a snitch. What's the worth and value of his story? Jennifer was doing this whole thing in her opening, right? About the prosecutor decides what the value is, what the witness gets for saying the right things. Okay? I'm doing the same thing. Now I'm crossing on that in her case. And what I want the jury to conclude is what? If he lies well enough, he gets out of prison. Okay? Worth and value comes from a wonderful line that the cop gave us. The numbers are much higher because this is now, we're into, thousands of pages of discovery, and we're talking about bait stamp numbers instead of the 4 pages that, we get in DUI cases. You called Aurora Police on the phone. This is cross-examination of the snitch. You talked to Detective Daly. You called back a week later to ask if he had talked to the DA. Told you he had. He told you, quote, that's why this is a big question. It's taken from the transcript. They will not do anything. They won't approach anybody, won't do anything until they know what you have. You were worried about telling your story before you knew what it was worth. Again, I understand. I'm violating the rules that I told you. All right, this was deep into a long cross-examination, and I knew the way that this witness was going to respond. All right, so there are exceptions to the rules, but detective told you it wasn't going to be worth anything unless you testified. It was 1 page on the podium. Okay, it's only a PowerPoint slide that makes it 2 pages. I didn't violate that goal. I told you that was what your projection was. The DA was going to determine the worth and value. This is where we get the title from of that information. The worth and value means how much you get in exchange. The only thing in this whole chapter that's not sourced. The better the information, the more valuable it is, the more value you get. This is just logical stuff. So if you lie well enough, you get out of prison, right? No, we're not going there because all of the rest of that stuff does it for us, right? We built the cone, right? We said there is a topic, it's important. We have a conclusion we want the jury to draw. And we're going to take him down through that to that conclusion step by step. All right. The order of chapters. How do we do this? So you write these chapters. And you know what? One of the things that's nice about this is that you don't have to be terribly organized to write the chapters. This is all about breaking things into small pieces. You say, I have to cross-examine a snitch who has told 3 stories on 4 different occasions. I have a chart that goes, and oh my God, how am I going to, you know what? All you have to do is say, you know what, there's a certain point that I'd like to make about this. Let me go find everything that helps with that point. And I do that chapter, and I close that file in my computer. And I say, what's the next thing that I can do? And later on, I can figure out what's the right order to do them in. Okay? Again, it's another one of the great values of this method is that it gives you all of this flexibility. Now, the fact is that when you're telling a story, as Paul taught us, as John demonstrated, as Jennifer demonstrated, chronologically is often not the best way or the most persuasive way to tell the story, right? And one of the things that you get out of that is the element of surprise as far as the witness is concerned. The witness doesn't know where you're going next. Here, the element of surprise. I love that slide so much. It's a cat, all right? But, that's where you want to be coming from sometimes, right? You kind of want to be coming from left field. And if you're not doing it chronologically, then you can come from left field. Hopefully the witness is not wearing a helmet the way this toddler is. Okay. Oh, here's my slide about what to do. So here's the thing. Sometimes you find yourself having really messed up in cross-examination, and you are not getting what you want. Or you go into a courtroom and you see a lawyer in a cross-examination who is not getting anywhere near what he or she wants from the witness. You sit down for a minute and you say, he is losing that battle to that witness, period. And why is that happening? The witness is running away, it's the witness's show, it's the witness's story, and it's not the lawyer standing there telling a persuasive story to the jury in cross-examination. 9 times out of 10, when you go back and you look at the transcript, or if you were there early enough in the day, you will see that this is not because the witness is out to screw the lawyer. It is because the lawyer invited the witness to do this. And the lawyer invited the witness to do this by violating one of the 4 rules, okay? Asked an open-ended question, wasn't sure about it, wasn't clear. But the fact is that we screw up and we do these things and we ask one question too many and we find ourselves balled up with a witness who is fighting with us. So what do you do under those circumstances? Trust me, you will get plenty of opportunity to test these when you are working tomorrow. Anybody have Tommy in their room, the actor Tommy in their room who is in a wheelchair? He will fuck with you like no one has fucked with you in your life, okay? He is just amazing, that guy. All right, so what are you gonna do? Certain tried and true techniques. You repeat the question, really a statement, in exactly the same words, which, if it is a long question, is nearly impossible to do. And which is, if it is a short question, is very easy to do. And emphasizes to the jury that it demands a yes answer, period. And that the witness is not giving it to you. And you may need to do this several times. But if you, in fact, have asked a leading question that is short and has only one new fact in it that demands a yes answer, when you do this, either the witness will concede or the jury will see that the witness is simply screwing with you and will not give you an answer that they know to be true. You would pay money for that to happen, right? In a destructive cross, because the jury then concludes there's a reason this witness will not say yes to what this lawyer is clearly saying, which is the truth. Right? It's again why your own personal integrity is always on the line here. My colleagues will tell you not to use taglines. I am telling you not to ask questions. I'm telling you to make statements, right? And taglines are things like, isn't it true? Isn't it right? Right? Take it off. Don't do it. Isn't it true that the car was red? The car was red. Isn't it true, sir? And it's all this like this lawyer stuff. Don't do it, take it away, it messes with your rhythm, it sounds like lawyer stuff. You don't want to sound like lawyer stuff. You're telling a story to the jury about a red car that was speeding down the road, okay? When the witness runs, there are several things here. You can add a tagline. People will say, you know, isn't that true? I like to simply make the statement again and go, yes, right? It makes it harder for them. The car was red. Well, you know, it was a kind of a burnt sienna that, you know, as I recall from my crayons when I was in, the car was red. Yes? When you go, yes, to some people, it's a very old, visceral, like back to when you were 6 months old response. You tend to go, yes, right? So the answer to my question is yes. Violation of the so rule. But, again, specific technique here. You've said blah, blah. You've said the car is red. You get an 8-word, a 10-word, a 10-sentence answer. You say, so the answer to my question is yes. And lots of times they concede and you don't have to go through the game. You're getting a long answer to a short question. They are telling you how to make the watch in response to your question about what time it is. If you interrupt, be polite, okay? Excuse me. Most people respond well to that, right? Excuse me. That sounds so sweet, doesn't it? Right. Excuse me. I will lick your heart out. Sunwolf does this one. I don't do it that much, but I'm told that it works. Witness is going, blah, you go. All you need is a breath, okay? All you need is a breath to get yourself in there. All you need is for them to take a breath, for you to slide in your next question, or for you to say, the car was red, right? That's another thing. You change your tone. You're going through, your car was red. Well, the car was red. The car was red! Right? I mean, there are all sorts of ways that you can do this, but what the jury is seeing is, it's very simple. You are saying with the tone of your voice. Consequently, boy, this is a violation of every rule that I have told you. And one of these things to be used, I think, in the most extreme of circumstances, but I will do this, okay? You know for sure you have asked a very short question that demands a yes answer, and you get blah, 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 that really takes a long time. And you say to the witness at the end, do you remember my question? Because they don't. They are so intent, right? And again, if you've asked a long question, you invited this, okay? And you don't get to do this. Only with the worst witness under the worst circumstances, but I give it to you. What all of these techniques allow you to do is not do the following thing. Argue. Bad. Very tempting. Instinctive. Kind of maybe what some of us are looking for in life as lawyers, maybe? Not a good idea here. So tempting. Oh my God, so tempting. So many times in a courtroom have I found myself in this argument. When you win, you lose. Right? When you win the argument, you lose. Don't argue with me. Talking over the witness, same thing. Asking the judge for help. This is it. You are done. Over. Period. Right? You ask the judge for help. You are finished. Why? Because you're not only not getting the help when the judge says, well, counselor, you asked a question, right? The judge has now explicitly endorsed the witness's behavior. The judge might as well have said to the witness, hit him again. Do it to him some more. And the judge is saying the same thing to the jury, right? Lawyer deserved it. Lawyer deserves it. Do not, under any circumstances, no matter how good you think your judge is, no matter how well you think you know this judge, do not ask the judge for help. Period. End of story. Help yourself. That's why you spent the time and money and energy to come here for 2 weeks, to learn how to help yourself, right? To learn to be the one that's in control of the courtroom. Surprise, surprise, we're going to echo theory and theme, okay? We told you, you go to start the case, you better be able to tell us very quickly and cleanly what your theory and themes of the case are. I'm going to tell you exactly the same thing about your cross-examination. You need to be able to tell us when you get up to start your cross-examination, what's my theory and what are my themes, okay? This is what cross that doesn't fit your theory looks like, okay? There's like a combination of, and people get pissed, what's going on, okay? I say, that's what that is. That is cross-examination against your theory of the case, right? What is that? What do I mean by that? The witness. This is your theory of the case, okay? You spent lots of time getting that bone together, figuring out why it tasted good, and that you were going to work on it and work on it and work on it in front of this jury, okay? This does not help you. It's very tempting. It's very tempting because this is the cop who's on the stand who you know said in his report that he stopped a white car. And in fact, the car is blue, right? And he's an idiot. Who doesn't want to show that the cop is an idiot, right? We're dying to show that the cop is an idiot. I love that fact. I can cross-examine on that. I can make so much hay with that, right? He doesn't know what he's doing. He wasn't paying attention. He's accusing my guy of being drunk, but clearly he was drunk because he didn't tell me he was drunk, right? Only the problem is that same cop gives me 5 facts that support my theory that the client was sober, right? He made the stop and he sees that the client gets out of the car and has no problem with his balance. He sees that the cop gives him his license and registration and proof of insurance without any trouble with dividing his attention or his manual dexterity. I don't want this cop to be an idiot. I want this cop to be just a guy who's up there telling his story, who is accurate and correct about his facts. That advances my theory of the case way more, right? But wait a minute. I can prove he's an idiot, right? Okay, well fine. Go chew your own leg off. Because that's what it is. You abandon your theory of the case, right? In order to go pursue something because it's fun and nice and exciting that does you no good. And in fact, causes you harm. All right, don't chew your leg off. What's your theory of the witness, right? My theory of this witness is that he is a cop who has made good observations, right? My theory of this particular cop is he's an idiot who can't tell the difference between white and blue. That's a very different cross, right? So, you have to be able to answer the question at the beginning. Is the witness providing accurate information? And of course, some witnesses, it's both. We're going to do some destructive, we're going to do some constructive cross. And most of the time when that's the case, we're going to do the constructive stuff first so that we can build them up. And then we're going to say to the jury, once that's over, we're going to signal, signpost to them in some way, now I need to talk to you about some things that you got wrong. Right? So sometimes we do have to do both, and it makes life more difficult and interesting and causes me more anxiety. Okay. Is the witness providing accurate information? Is the witness mistaken? Is the witness misinformed? That's different than mistaken, right? It's clearly different than providing accurate information. Incompletely informed. Different theory, different tone, different way of doing that cross. What's your theory of the witness, okay? Now, is the witness lying? Okay, we like that, we deal with that a lot, we want to spend some time on that. Okay, but is that the end of the game? Is a liar a liar a lie? Is a lie a lie a lie? No, it's not. Is the witness conniving and malicious? Conniving and malicious, right? Do we know who that is?
Lance Armstrong.
Lance Armstrong. Okay, brief digression. You know who that is? Lance Armstrong. Know who that is? That's me. Swear to God, that's me. You don't believe it? Let me show you this. Seriously, I gotta show you this. For real. Check it out. Selfie on light. That's the higher time. See that? See there's Lance. Alright, sorry. I mean, you know, if you pass Lance Armstrong on a bike, right? Do you pass up the temptation to show that to people? What am I doing right now? Chewing off my own leg. I understand. Alright, back to, how do I get back to where I was going? Okay, here we go. This is what happens in cross. If you stuff and chew off your own legs. Where's the thing? Where? Left where? Bottom? Bottom right. That's where I was. There it is, there it is. Sorry. Okay, I won't do that anymore. Right, so is the lie that's being told conniving and malicious, or is this, somebody that's being controlled or is afraid of someone else, right? This guy told us some lies about Iraq. Most of us thought he was being controlled or was afraid of this guy. All right. It's got to have a theory and it's got to have themes. What you would really love, right? Wouldn't you love it if you got the opportunity before you did the cross to look over at the jury and say, okay, this guy that's coming up next is lying, and he's lying because he's afraid of this prosecutor. Would you do that if they gave you the opportunity? Yeah, you would. The only way that you'd ever be able to do that is if you had thought that out and had it in your head. And I'm going to tell you that I think that it is an extraordinary exercise in empowering you and in empowering your cross to do that, to have in your head what your theory of the witness is, and to know what themes you want to sound for that witness. Here's what else I'm going to tell you. I should have this as a rule because I believe that it is as important as the other rules that you write the cross out. That you literally write it on a piece of paper. All that stuff that I was saying about on one page of paper, I mean that. I mean that you sit down and you write the chapters and that you put the source in and that you do it for every question that you possibly can. For all of the reasons I've said and some more. The some more being this. One, when you do that, it gives you a mastery of the facts of the case and a mastery of the discovery and a mastery of the transcripts that you can't get if you simply go through and read them page by page. If instead you are reading them, mining them for the little nuggets that advance your theory and theme, you get a much better mastery of it. Second, when you've written them all out and you've titled these chapters, and you go back and you look at the titles of the chapters, you know what you have? You have what really becomes a really nice rough outline of your opening statement and your closing argument. Because think about it. The stuff that you have to cross, the most important witnesses in your case on, are those subjects, are those topics. It's the stuff that you're most afraid of, that you have to go try and do something to destroy. It's the stuff that's most beneficial to your theory of the case. And now you've got the payoff, not only of having gotten this mastery and having this wonderful cross-examination ready to go, you're also well down the road to having your opening statement written, and well down the road to having your closing argument, which actually you should have had written anyway, right? Because it's really the only way to come up with a good theory of the case. That's really what we're talking about, right? Is working backwards here. I think Colette told you, be calm and work backwards, right? You gotta know what closing you're gonna give in order to know what your theory and theme is, in order to know what you're gonna cross on. This, again, having these chapter headings is gonna allow you to do that. It allows you to stay organized during the cross-examination. It allows you to be in control. Most importantly, it allows you to continue telling your story. And telling your story means that you are fighting on home territory, right? If all we're doing is counterpunching, if all we're doing is trying to say, well, we're going to show that they can't believe that story beyond a reasonable doubt. If all we're doing is responding to the story that the government is telling, that's nowhere near as strong a position to be in as if we can be on home turf, right? Home field advantage is a real thing. Debaters know that, if you let me frame the issue, I win the debate every time, right? You come over and fight on my territory, in my street, and you want to do house-to-house fighting on my streets, I'll tell you who's going to win most of the time. I am. our story, our territory, right? So I'd like to give you a little visual for that, all right? This is what it means to fight in your own territory. Now, what you think
You've certainly been brave today.
is that I'm going to show you
There's a red. Oh,
snake is a bunch,
we went back to the war.
right?
Look at this.
This is the snake, right? This is what it looks like.
Can you hear that? Can you believe it? You see my baby?
Huh.
That's what she did. Look at that, eh?
These snakes and bunnies, right? This snake flies. It's his territory, right? Don't come into my house. I will chase your ass up the tree. Right? This snake is going up the tree, and he messed up a bunny rabbit. Okay?
Oh, God. He ran up that tree.
The narrator, I can play it to you for you again. The narrator is great. He's going to show you the red of a tree. That's what it means to fight on your own territory, okay? Last visual. Here's what it looks like if you don't go home and prepare tonight. I have done this next cross, okay? Trust me, we have come to fight, and by God, we are going to fight. But we are not really prepared for the fight. Those Marines in the crowd, this originally came to me as why no one is afraid of the French. So I think these are French Marines. I don't know. So they're ready for a fight, right? Armed to the teeth. Not us, folks. It is quicksand. Going to battle and you don't realize that you're going to quicksand is a problem. But hey, we're going to shoot somebody, right? We're going to fight. I'm going to cross this guy. This is a gun. I'm going after him, right? That's you asking for help with the gun. Like that, right? I'm telling you, I have done this wrong. Judge, please pull me out. Pull me out. You cannot do this if you don't spend the hours in advance to write it out, to source it, to have a theory, to have a thing, to know what you are going to accomplish at every little goal with this witness. That's why you gotta go put the time in tonight, so that you get props from these people tomorrow and they don't throw shit at you. So that when you go back, you can be the warrior that Paul wants you to be, that you have the theories and themes that Colette told you to have, that you can tell these stories, starting in jury selection, to people who will listen, right? The way Jeff Robinson told you they will. And you will take the opportunity in cross to tell the story. Thank you.